Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey. Mark has selected this case in order to highlight the different employment law in the state of Montana under the Wrongful Discharge from Employment Act, WDEA, which is the only state in the country that uses a for-cause termination statute instead of an at-will rule. Mark is highlighting Montana cases to give listeners a new perspective in comparison to the at-will rule followed in every other state in the country.
And it really is a completely different landscape out there.
It really is. I mean, just imagine this scenario for a second. You report your boss for, using racial slurs and sexually harassing female coworkers.
Which is a massive deal.
Right. And you do everything by the book. You follow the corporate rule book to the letter, taking your concerns all the way up the ladder.
Yeah, you do exactly what HR tells you to do.
Exactly. But then a few days later, your HR record is permanently downgraded by that very same boss.
Oh, wow. Yeah.
And it gets worse. Shortly after that, you go into the hospital for surgery, and while you're recovering on medical leave, you wake up to find out you've been fired.
Talk about a nightmare scenario.
Right. So today, we're basically acting as legal archaeologists. We are scraping away layers of corporate sediment to examine this massive, multi-year legal battle. It's called Robert A. Eaton v. Montana Silversmiths.
In this case, it really ping-ponged around, didn't it?
Oh, yeah. Between a U.S. District Court and the Ninth Circuit Court of Appeals for years, we've got these massive rulings from 2022, 2023, and 2025.
So to really unpack this, we need to look at the timeline. It spans from 2015 all the way to his termination in the summer of 2017.
Right.
It's got explosive closed-door meetings, mysteriously revised documents, and just a total breakdown in basic HR compliance.
But before we get into the drama, we have to start with the geography. Like we said at the top, Robert Eaton was suing in Montana.
Which changes everything.
Yeah, because it means that, frankly, 98% of the people listening to this are currently working under a completely different set of legal assumptions than Eaton was.
Right. Most American workers operate under what are called at-will employment.
Right. So break that down for us. What does at-will actually mean in practice?
So that doctrine is basically the bedrock of American labor law. 49 states operate under the at-will rule. And in its simplest, most brutal form, it means a company can terminate you at any time.
Just boom, you're gone.
Exactly. For any reason, or honestly, for no reason at all, provided the reason doesn't violate a specific federal protection, like race, religion, or gender discrimination.
So they can't fire you for being a certain religion?
Right, but your boss can fire you because, they don't like the color of your car, or because you root for a rival sports team.
Wait, really? The car color thing is legal?
Oh, totally legal. Or simply because they want to cut costs to boost quarterly earnings. They do not have to prove you were bad at your job, and they definitely do not have to justify the termination to you.
Wow. It's just a binary switch. You're employed until the exact second they decide you aren't. There's no inherent right to fairness.
None at all. But Montana threw that playbook right out the window.
Yeah, Montana's the lone wolf here. They passed the Wrongful Discharge from Employment Act, the WDEA.
Right. And to give you some historical context on why that happened, back in the 1980s, Montana courts were handing down these massive multi-million-dollar punitive damage awards to employees who had been fired unfairly.
Oh, so the businesses were getting crushed in court.
Exactly. The business community completely panicked. So to stabilize the state's economy, the legislature struck this grand compromise.
What was the trade-off?
Well, they capped the amount of money an employee could win in a lawsuit. But in exchange, they totally eliminated at-will employment.
Wow. So they gave up the right to fire at will just to stop the bleeding from those huge lawsuits.
Yep. Under the WDEA, once an employee completes their probationary period, which is usually like the first 6 to 12 months, the employer completely loses the right to fire them on a whim.
Okay, so from that point forward, a discharge is only lawful if the employer has good cause.
Exactly. Good cause.
But I mean, good cause is one of those legal phrases that sounds intuitive, but usually has a very rigid definition. Like, if I'm an employer in Montana, what actually gives me the right to fire someone?
Right. So the Montana statute defines it as reasonable job-related grounds for dismissal. And this typically falls into 2 buckets.
Okay, what's the first bucket?
The first one is employee behavior. So Failing to satisfactorily perform job duties, chronic absenteeism, or, actively disrupting operations.
It's just being terrible at your job, basically.
Pretty much. And the second bucket is structural, legitimate business reason.
What counts as a legitimate business reason?
The Montana Supreme Court says it has to be a decision that isn't false, whimsical, arbitrary, or capricious. And it has to have some logical relationship to the needs of the business.
Right. So you can't just make something up.
Exactly. And furthermore, the WDEA contains this really strict procedural safeguard.
Oh, yeah, the handbook rule.
Yes. If an employer violates the express provisions of its own written personnel policy, like, say, firing you, without giving the 3 written warnings they promised in the handbook,
Then what happens?
that is automatically a wrongful discharge, regardless of how terrible your behavior was.
Wow. So the handbook becomes a legally binding contract in a way it simply isn't in states like New York or California.
Exactly. It's a huge shift in power.
Okay, so with that baseline established, let's look at Robert Eaton. He worked in the engraving department at Montana Silversmiths, right?
Yeah, they're this prominent company that manufactures Western jewelry and belt buckles.
And in the summer of 2017, he gets terminated. So he sues under the WDEA, claiming he was fired without good cause.
Right, because he genuinely believes the termination is tied to those harassment reports he'd been filing.
But under the WDEA framework, the company gets the first move in court, right, to present their legitimate business reason.
They do. And Montana Silversmiths, they didn't defend the lawsuit by attacking Eaton's daily engraving skills. They zoomed way out.
They pointed to the economy.
Exactly. They pointed to a massive macroeconomic crisis hitting their specific market. A reduction in force, commonly referred to as a RIF.
Right, the dreaded RIF. So what happened to their business?
Court documents show that leading up to 2017, the company learned it was going to lose a major long-standing sponsorship agreement with the American Quarter Horse Association, the AQHA.
I mean, for a company that specializes in Western lifestyle products, losing the Quarter Horse Association isn't just losing a client.
No, it's losing a flagship revenue stream. The records note this was a $750,000 hit.
Wow. That is a catastrophic shortfall for a mid-sized manufacturer.
Oh, totally. And that specific contract severely impacted the workload of the engraving department, where Eaton worked.
So they had to cut costs to survive, which meant shedding payroll.
Exactly. The company initiated a 3-phase RIF. Over the course of a year, they let go of 30 employees across the whole organization.
But Eaton survived the first 2 rounds, didn't he?
He did. But when phase 3 arrived in the summer of 2017, his name was pulled.
You know, whenever a company executes a mass layoff, the biggest legal liability is how they choose the specific human beings who lose their jobs.
Oh, absolutely.
I mean, even if you have to cut 10 people, why those 10? You can't just throw darts at a board, right?
Right. And Montana Silversmiths use a highly structured tool to insulate themselves from that exact liability. They used a cross-training matrix.
The matrix. Just the word sounds like a corporate shield.
It really is. The cross-training matrix is a staple of corporate restructuring. It's basically a mathematical system designed to quantify an employee's value during a downsizing.
So how does it actually work in practice?
Basically, management listed various tasks and departments across the top of a spreadsheet and employee names down the side.
Okay.
And then they scored every worker based on their skills, their cross-training capabilities, past performance evaluations, disciplinary history, and just overall versatility.
Because when a company shrinks, it generally can't afford highly specialized employees who only know how to run one machine.
Yeah.
Right.
Right. They need utility players. The generalists who can pivot from station to station depending on the daily bottleneck.
Makes sense. And when the math settled on this matrix, where did Robert Eaton land?
He had the absolute lowest score in the entire company.
The lowest in the whole company.
Wow.
Yep. He lacked the internal cross-training the company deemed essential for their leaner, restructured future.
So, armed with this data, Montana Silversmiths went to the judge and laid out a textbook WDEA defense.
They really did. They proved the loss of the $750,000 AQHA contract. They proved the financial necessity of the 30-person RIF.
And they presented the standardized cross-training matrix showing Eaton at the very bottom.
Exactly. And they argued that this was the very definition of a legitimate business reason. It wasn't arbitrary. It wasn't whimsical. It was just basic corporate survival math.
You know, if I'm an employee listening to this, even in a quote-unquote for-cause utopia like Montana, this feels like a massive vulnerability in the law.
How so?
It's like a professional sports team cutting a player the general manager personally dislikes. The player complains to the media, causes friction, and the GM wants him gone.
Right.
Then suddenly, the league salary cap drops. The GM cuts the player and tells the press, well, we had to reduce payroll, and his skill set just didn't fit our new offensive matrix.
It provides the perfect cover.
Exactly. It's mathematically sound cover to execute a termination they wanted to do anyway. A matrix can be reverse engineered to make sure a specific target ends up with the lowest score.
And look, the legal system is highly aware of that exact dynamic. It is literally the foundation of employment discrimination litigation.
What do they call it?
The law calls this concept pretext. Pretext is a fabricated justification masking the true underlying motive.
Okay, so under the WDEA, once Montana Silversmiths presented their matrix in the RIF, the burden of proof immediately shifted back to Robert Eaton, right?
Right. Eaton had to legally prove that the matrix was a pretext. According to long-standing Montana Supreme Court precedent, he had to demonstrate that the RIF, as applied to him specifically, was not the honest reason for the discharge.
But how does an employee actually prove a spreadsheet is lying?
It's really hard. Eaton argued that management purposely boxed him in. He claimed they intentionally denied him opportunities to cross-train on other machines.
So keeping his skill set artificially narrow over the years, precisely so, his matrix score would tank when a layoff eventually happened.
Exactly. It's a really compelling narrative of corporate sabotage. But, and this is but a narrative is not evidence.
Right.
When this case hit the summary judgment phase, Eaton ran into a brick wall of legal procedure.
Let's talk about summary judgment for a second. That's essentially the trial before the trial, right?
Yeah, basically. The company files a motion asking the judge to throw the case out before it ever reaches a jury. They argue that even if everything the plaintiff says is true, they still don't have enough evidence to win under the law.
Because companies spend enormous resources fighting to win at summary judgment. Putting a case in front of a jury is incredibly unpredictable.
And wildly expensive. So to survive summary judgment, a plaintiff cannot rely on their own accusations.
You can't just stand at the plaintiff's table and say, I know they rigged it because they didn't like me.
Right. You need the receipts. You need an email chain between managers saying, make sure Eaton doesn't get trained on the new laser engraver so we can cut him.
Or you need testimony from other floor workers confirming you asked for training and were systematically denied while others were approved.
Exactly. And Eaton simply did not have those receipts.
He didn't have any of it.
None. The Ninth Circuit Court of Appeals, when they reviewed the WDEA claim in 2023, pointed out that Eaton relied almost entirely on conclusory statements.
Meaning what, exactly?
Meaning he offered his own sworn testimony and uncorroborated answers to interrogatories, but he failed to produce material, substantial evidence.
So he couldn't mathematically prove the scores on the matrix were falsified based on the skills he actually possessed.
Right. And he couldn't produce documentation showing he requested specific training and was denied.
Man. Because he couldn't push past his own suspicion, the courts ruled that Montana Silversmiths' defense held up.
They did. The economic downturn was verified, the standardized metric was applied, and the WDEA claim just collapsed. The layoff was deemed legally sound.
So the immediate takeaway from this WDEA portion of the litigation is that an employer's adherence to a structured, documented process during an economic downturn provides this incredibly durable shield.
Absolutely. Even in a state that requires good cause, a documented RIF is a very strong defense.
But as we deep dive into this, the RIF is only the surface layer of this archaeological dig. The Ninth Circuit agreed the RIF was valid in June of 2017, but Eaton's lawsuit alleged the target was painted on his back long before that quarter-horse contract ever fell through.
Right. The true friction in this workplace wasn't about engraving skills at all. It was about a deeply toxic environment and a management hierarchy that turned on a whistleblower.
So we are shifting away from the state laws of Montana and moving into the heavy artillery of federal law. Title VII of the Civil Rights Act of 1964.
Yes. Let's wind the clock back 2 years. We're moving away from the summer of 2017 and landing in 2015.
Okay, set the scene for us.
So Eaton is working his station in the engraving department. His direct supervisor is a guy named Justin Deacon. And according to the court records, the floor culture under Deacon was highly problematic.
To put it mildly, Eaton begins making a series of internal reports. On July 29, 2015, he goes directly to Colette Schlehuber in Human Resources.
Right.
And he formally reports instances of sexual harassment and the use of racial slurs in the department by Justin Deacon.
And reporting sexual harassment and racial slurs triggers immediate, strict federal oversight. Under Title VII, an employer has a legal duty to investigate and remedy a hostile work environment.
But Title VII also recognizes that employees will never report this behavior if they are terrified of being fired by the very people they're turning in.
Right. Exactly. Therefore, the law includes a really powerful anti-retaliation provision. When Eaton went to HR, he engaged in what is legally defined as a protected activity.
And Eaton didn't stop with HR. Later in 2015, he brought the same issues to Matt Weinman, a vice president of operations, and David Cruz, who was Justin Deacon's direct manager.
Right. He reported racially charged comments made by Deacon.
And then, fast forward a bit to January 24, 2017, Eaton sits down with David Cruz again. This time, he expands the scope.
Yeah, he reports that Deacon is showing blatant favoritism toward his own son, Travis, who also works in the department, and he reiterates that Deacon's sexual harassment of female employees is ongoing.
Which creates a really critical dynamic, legally speaking. Title VII protects employees who oppose unlawful employment practices, even if they aren't the direct victims of the discrimination, right?
Yes. The appellate courts have long established that complaining about the treatment of others in the workplace is fully protected.
So Eaton is basically wrapping himself in a federal shield. Over 18 months, he has methodically climbed the corporate ladder HR, management, VPs, creating a massive paper trail of protected activity regarding his supervisor's behavior.
Which sets a high-stakes psychological trap for what happens next.
Let's get into what happens next. It's April 4, 2017. Just a few months after his last report to management, Eaton sits down for his annual performance evaluation.
The document is referred to throughout the litigation as PEV.1, Performance Evaluation Version 1.
And the person conducting the review and writing the appraisal is his direct supervisor, Justin Deacon.
I mean, the power dynamic in that room is just incredible. You have a supervisor evaluating the performance of a subordinate who has spent 2 years trying to get him investigated by the vice presidents.
It's wild. Looking at PEV.1, the document is a fascinating piece of corporate maneuvering. Eaton gets an overall appraisal score of 2.70.
Right, and their internal scale sets a 2.0 as exceeds expectations and a 3.0 as meets expectations.
So 2.70 means he is fundamentally competent.
Right, and in the objective categories, Deacon actually praises him. Under self-starter, shows resourcefulness, Deacon writes that Eaton is a very hard worker, always on task.
So he is undeniably producing the work. The friction entirely exists in the subjective categories.
The behavioral metrics, which are notoriously difficult to quantify and incredibly easy for a manager to weaponize.
In 2 specific categories, interaction with coworkers and resolves conflicts in an appropriate manner, Deacon gives Eaton a 4.
Which is the lowest possible failing grade. It translates to does not consistently meet expectations.
The dreaded soft skills trap. If a manager wants to stall your career but can't point to a flaw in your actual output, they hit you on culture fit or teamwork.
Oh, it happens all the time. But Deacon didn't just check a box. He had to write comments justifying those failing grades.
And this is where the ink hits the fan. Under interaction with coworkers, Deacon wrote that Eaton, quote, at times creates unwelcoming environment in regard to Travis, while at the same time interacting well with Rick and Brian.
Travis being Deacon's own son.
Unbelievable.
The supervisor is officially docking a subordinate's pay or career trajectory because the subordinate doesn't get along with the supervisor's child. It borders on textbook nepotism.
But the second comment is the one that actually triggered the federal lawsuit. Under the category for resolves conflicts, Deacon wrote that Eaton, quote, sidesteps proper reporting of concerns outside the management hierarchy.
Wow. That sentence is the absolute epicenter of the legal dispute.
It's maddening. It's exactly like a high school student witnessing a teacher bullying someone, quietly reporting it to the principal, and a week later getting an F in citizenship from that exact same teacher with a note saying, student has a bad habit of tattling to the principal instead of keeping classroom issues inside the classroom.
That's a perfect analogy.
It is raw, documented retaliation masked as a behavioral critique. Justin Deacon is officially punishing Robert Eaton for taking the harassment complaints to HR.
And that is Eaton's core allegation. It forms the basis of a Title VII retaliation claim. But in the federal court system, proving retaliation requires a plaintiff to navigate one of the most famous and complex legal frameworks ever created.
The McDonnell-Douglas burden-shifting framework.
Exactly.
To really grasp why this case ping-ponged through the courts for 8 years, we need to understand why the Supreme Court created this framework in the first place. This goes back to a landmark 1973 case, right? McDonnell-Douglas Core v. Green.
Yeah, the history here is vital. So Percy Green was a black mechanic and civil rights activist working for McDonnell Douglas. He was laid off in a general reduction.
Okay.
To protest the company's hiring practices, Green participated in a highly disruptive stall-in, illegally parking cars to block the roads to the plant.
Wow, okay.
A few weeks later, the company posted open jobs. Green applied, and the company refused to hire him, citing his illegal participation in the stall-in.
But Green sued under Title VII, arguing the true reason they wouldn't hire him was his race and his civil rights activism.
Exactly. And the Supreme Court recognized a massive problem. Following the Civil Rights Act of 1964, overt discrimination mostly vanished.
Right, companies stopped hanging signs saying Irish need not apply or putting racial quotas in writing.
Right, they got smarter. They started using behavioral or business excuses to cover up discriminatory motives. The courts needed a structured way to smoke out hidden biases when there was no smoking gun email.
So they invented a 3-step dance.
Yes. Step 1 is the prima facie case. The employee has the initial burden to show that, on the surface, things look highly suspicious.
And for a retaliation claim, what does the employee have to prove?
3 elements. First, they engaged in a protected activity. Second, they suffered an adverse employment action. Third, there is a causal link between the two.
Let's run Robert Eaton through Step 1. Protected activity. Yes, reporting racial and sexual harassment to HR is ironclad. Adverse employment action. Well, the Ninth Circuit has explicitly ruled that an undeserved negative performance review that lowers your overall score and enters your permanent personnel file absolutely qualifies as an adverse action. It stunts your earning potential and sets you up for the chopping block.
That leaves the third element, the causal link. Did the protected activity cause the bad review?
Right.
In employment law, causality hinges entirely on knowledge and timing. A supervisor cannot retaliate against you for a complaint they don't know exists.
The plaintiff must prove that the decision maker actually knew about the protected activity before they took the adverse action.
Yes. And the timeline in this case turns into a complete chaotic mess because the very next day after this review was delivered, the entire situation exploded.
Walk us through that night. It's the evening of April 4th, 2017.
So Eaton has just been handed PEV.1 by Deacon. He reads the comment about sidestepping proper reporting, and he is furious.
Understandable.
He goes straight to the vice president of operations, Lance Nearby. He complains bitterly about the review and reiterates his harassment claims against Deacon.
He also vents to a coworker, Rick Waltner, who gives him the starkest advice you can hear in a corporate setting.
Right. You should get a lawyer.
Boom. The friction transitions from an HR headache into a looming federal liability.
Yeah. And the next morning, April 5, VP Nearby calls a meeting. It's Nearby, Justin Deacon, and Robert Eaton in a closed room to hash out the evaluation.
And the pressure cooker blows its lid.
Oh, completely. According to sworn deposition testimony from Nearby, Eaton completely lost his temper. He was screaming, yelling obscenities, and acting aggressively toward his supervisor.
From a purely human perspective, you can feel the frustration. He's been reporting severe misconduct for 2 years, nobody has fixed it, and now his career is being sabotaged on paper for speaking up.
It's infuriating, but legally, exploding in a room with the vice president hands the company an immediate documented justification for severe disciplinary action.
Because you can't scream obscenities at management, regardless of how justified your anger is.
Exactly. But the VP, Lance Nearby, doesn't suspend or fire Eaton on the spot.
What does he do?
Instead, right there in the meeting, he physically alters the performance evaluation. He creates a brand new document, PEV.2.
He starts editing the history. What gets changed?
He focuses on the comment regarding Eaton's interaction with coworkers. He deletes the sentence complaining that Eaton won't acknowledge Travis Deacon's existence.
Good move, getting rid of the nepotism evidence.
Right, and he replaces it with a highly sanitized corporate phrase. Challenging relationship exists between employee and direct supervisor.
Crucially, though, he leaves the failing numerical scores identical. The 4s remain.
Yeah.
Why bother changing the words if you're keeping the failing grade?
Well, Nearby testified that he altered the text as a direct result of Eaton's meltdown in that very meeting. He claimed he was trying to diffuse Eaton's hostility by softening the language while accurately documenting that, given the screaming and swearing currently happening in the room, a challenging relationship truly did exist.
This sequence of events leads to a catastrophic procedural error when the case first reaches the U.S. District Court in 2022.
Right. a massive error. Montana's Silversmiths filed for summary judgment to kill the retaliation claim. And their lawyers pointed directly to PEV.2.
Okay.
They argued they had a perfectly legitimate, non-retaliatory reason for adding the phrase challenging relationship. I mean, the employee was literally screaming obscenities in the room.
And the district court judge fell for it completely. The judge wrote in the 2022 order that an employee yelling profanities at a supervisor certainly reflects a challenging relationship that negatively impacts the workplace.
Right.
The judge ruled the company had a valid reason for the evaluation and tossed the retaliation case out of court. Case closed. But reading that ruling, the temporal paradox is glaring.
It violates the fundamental laws of cause and effect.
Exactly. The swearing and the meltdown happened on the morning of April 5th. But the original failing scores and the retaliatory comment about sidestepping were written into PEV.1 on April 4th.
They got the timeline completely backwards.
The company used Eaton's reaction to the retaliatory review as the legal justification for the retaliatory review. It's like a police officer walking up and punching you in the face without provocation, and when you yell out in pain, they arrest you for disturbing the peace.
Wow, yeah.
And the judge says, well, you were disturbing the peace, so the arrest is valid, completely ignoring the initial illegal punch.
That's exactly what happened. So Eaton's legal team appealed to the Ninth Circuit Court of Appeals, highlighting this exact paradox.
And what did the Ninth Circuit do?
In 2023, a 3-judge appellate panel reviewed the timeline and immediately caught the lower court's error. They issued a memorandum stating that the district court entirely failed to discuss whether the initial PEV.1 evaluation was retaliatory.
They completely skipped it.
Yeah. The Ninth Circuit ruled that Eaton had easily established a prima facie case regarding the first document. They reversed the summary judgment and kicked the case back down to the lower court.
When an appellate court kicks a case back down, it triggers a powerful procedural mechanism called the law of the case doctrine, doesn't it?
Yes, it does. And this isn't just a suggestion from the higher court. It's a mandate.
Explain that for us.
The law of the case doctrine prevents endless litigation loops. It dictates that a trial court must follow an appellate court's resolution of a legal issue in all subsequent proceedings of the same case.
Okay, so the district court couldn't stubbornly stick to their logic about the April 5th meltdown.
Exactly. The Ninth Circuit bound their hands. In the final 2025 ruling, the district court judge explicitly acknowledged this, stating they were now forced to analyze PEV.1 in a vacuum, focusing strictly on the mindset of the managers on April 4th before anyone raised their voice.
The legal system requires an incredibly surgical unspooling of events. Human beings experience conflict as a chaotic knot of emotions and reactions, but the courts are forced to isolate cause and effect down to the specific hour a document was drafted.
It's very sterile.
But while the lawyers were busy arguing over the timeline of a performance review, Eaton was facing a much more immediate physical crisis.
Yeah.
His body was breaking down, which triggered an entirely different legal trap.
Right, let's reorient the timeline here. The explosive meeting over the review occurs on April 5, 2017. Just over a week later, on April 14, Eaton goes on scheduled long-term medical leave
to undergo right carpal tunnel release surgery. I mean, engraving is highly repetitive, fine motor work. Decades of it will inevitably destroy the nerves in your wrists. Because it's a workplace injury, he correctly goes on paid workers' compensation leave. He has the surgery and begins his recovery.
And then 6 weeks later, on June 1st, 2017, Eaton calls Colette Schlehuber in the HR department.
The same HR person from before.
The very same. He officially requests Family and Medical Leave Act benefits, or FMLA, to cover his continuing time off.
For those who haven't waded into the weeds of federal leave policies, the FMLA is an incredibly powerful piece of legislation.
Oh, absolutely.
It grants eligible employees the absolute right to take up to 12 weeks of unpaid leave for serious medical conditions. But the true power of the FMLA isn't the time off. It's the armor it puts around your position.
Right, the job protection.
The law guarantees that when you return, you must be restored to your original job or a strictly equivalent position. It is a federal shield protecting your livelihood while you heal.
So Eaton requests his FMLA paperwork. And Colette Schlehuber, the HR manager, tells him over the phone that he is ineligible for FMLA.
On what grounds?
Her reasoning was that he was already receiving paid workers' compensation. She outright refuses to provide him with the standard FMLA certification forms.
This systemic dysfunction in corporate HR departments often surfaces exactly in this intersection of policies. Workers' compensation is usually handled by an insurance carrier focused on liability and payouts. FMLA is a federal compliance issue usually handled internally.
Right, it's the silo effect.
The silo effect means the people handling the money often don't understand the federal job protections. If you get hurt on the job and receive workers' comp money, do you forfeit your federal FMLA job protections?
Absolutely not. And what makes this refusal so egregious is that Schlaber wasn't just violating federal law, she was violating Montana Silversmiths' own printed employee handbook.
You're kidding.
Nope. The company's manual explicitly stated that workers' compensation leave would be designated as FMLA leave and would run concurrently.
They happen simultaneously. The workers' comp policy cuts the checks, and the federal FMLA policy guards the desk. You are legally entitled to both. The HR manager was fundamentally incorrect about basic employment law.
And this refusal immediately forms the basis of Eaton's next lawsuit, an FMLA interference claim.
How does that work?
Well, under federal law, it is unlawful for an employer to interfere with, restrain, or deny the exercise of FMLA rights. But the Ninth Circuit's 2023 ruling provides vital clarity on what interference actually looks like on the ground.
Right. It doesn't require a boss physically barring you from the hospital.
Exactly. The appellate court pointed to the Code of Federal Regulations, noting that interference includes discouraging an employee from using their leave.
Simply lying to an employee, even an accidental lie born of HR incompetence, and refusing to hand over the blank application form is enough.
Yes. The Ninth Circuit ruled that telling Eaton he didn't qualify and withholding the form was textbook discouragement. The company broke the law.
But proving a company broke a regulation is only half the battle in civil litigation, isn't it?
Yeah, unfortunately. The second half is proving that the violation actually harmed you. This introduces the legal burden of prejudice.
Prejudice. What does that mean in this context?
As the Supreme Court established in a case called Ragsdale v. Wolverine Worldwide, a plaintiff must demonstrate that the employer's FMLA violation caused real, measurable damage to their employment status.
And Eaton's argument for prejudice seems incredibly straightforward. He went on leave April 14th. FMLA guarantees 12 weeks of protected leave, which would have carried his job protection deep into July.
Right.
But on June 15th, before his 12 weeks were up, the company officially terminated him. His argument is essentially, you fired me while I was supposed to be wrapped in the federal FMLA shield. If HR hadn't illegally withheld the paperwork, I would have been protected until July. The lack of paperwork cost me my job.
It is a highly logical argument, but it crashes into a massive, unyielding corporate reality. Montana Silversmiths defense lawyers bypassed the HR incompetence entirely and pointed right back to the macroeconomic crisis.
They pointed back to the cross-training matrix. The archaeological layers are compressing. The FMLA claim collides with the RIF.
The FMLA is not a magical, impenetrable force field. The Department of Labor regulations explicitly state that an employee on FMLA leave is not entitled to any right, benefit, or position of employment other than what they would have been entitled to had they not taken the leave.
Okay, so the FMLA protects you from being fired because you took medical leave. It does not protect you from a company-wide meteor strike.
Exactly. If the building burns down, you don't still have a job just because you were on medical leave when it happened. A 30-person restructuring driven by a $750,000 revenue loss is a corporate meteor.
Precisely.
Yeah.
So the burden shifted to the employer to show Eaton would not have otherwise been employed at the time reinstatement was requested.
And they showed the judge the matrix. Eaton had the lowest score. The courts ruled that Eaton's fate was sealed by the spreadsheet months before he ever requested the paperwork. He was going to be terminated in Phase 3 of the RIF on June 15th, regardless of whether he was sitting at his engraving desk, sitting at home on workers' comp, or sitting at home holding approved FMLA paperwork.
Therefore, because his termination was a mathematical certainty due to the RIF, the HR department's illegal refusal to give him the paperwork didn't alter his timeline. It didn't cost him his job.
Right. He suffered no prejudice. The FMLA claim fails. The company broke the rules, but because a larger, unstoppable force was already in motion, they escape liability.
It's an incredibly bitter pill for a plaintiff to swallow. Eaton lost the WDEA claim over the RIF. He lost the FMLA claim over prejudice. He also lost disability and age discrimination claims. The company's legal fortress seems impenetrable.
But the courts are still holding that single surviving artifact.
The Title VII retaliation claim regarding PEV Bot 1, written on April 4th, they claim the Ninth Circuit revived.
Exactly. In 2025, the district court is finally forced to run that single document through the remainder of the McDonnell-Douglas burden-shifting framework.
So let's look at that. We established Step 1. The prima facie case. Eaton engaged in protected activity. The review was adverse. The final hurdle of step 1 is causality. Did Vice President Nearby know about the harassment complaints when he helped draft PE v.1 on April 4th?
And this is where the judge combed through the deposition transcripts and just struck gold.
What did they find?
Colette Schleihuber, the HR manager, testified under oath that she did discuss Eaton's allegations of sexual harassment and racial discrimination directly with VP Nearby in 2017.
Wow. Okay.
Furthermore, David Cruz, the other manager Eaton complained to, was asked in a deposition if he relayed Eaton's concerns to Nearby. Cruz answered, "If I said I would, I probably did."
It's not a conviction signed in blood, but at the summary judgment phase, a judge is legally required to view all evidence in the light most favorable to the non-moving party, which is Eaton.
Right. A reasonable jury could easily hear that testimony and conclude that VP Nearby knew exactly what Eaton had been reporting.
And since Nearby admitted he directed Supervisor Deacon to insert the negative comments into the review, the causal chain is locked. Step 1 is victorious. The burden shifts to the company for step 2.
Under McDonnell-Douglas Step 2, the employer must articulate a legitimate, non-discriminatory reason for their action.
How heavy is that burden?
The burden here is relatively light. They don't have to definitively prove it to the judge. They just have to produce evidence that raises a genuine issue of fact. They must explain why they gave Eaton failing scores without relying on retaliatory animus.
Let's test the company's defense on the 2 specific comments. First, Deacon's note that Eaton creates an unwelcoming environment in regard to Travis. How does a company legally justify a supervisor punishing a worker for not liking the supervisor's son?
They flooded the record with corroborating testimony. VP Nearby testified that Eaton's communication style left the team feeling like they were walking on eggshells.
Okay, vague but sure.
David Cruz testified that Eaton would get so intensely red in the face during disagreements that Cruz actively avoided working with him.
That's a bit more specific.
And Travis Deacon himself provided a highly specific, disturbing anecdote. He testified under oath that Eaton told him a story on the floor about beating a guy up one time really bad, which made Travis feel physically tense and uneasy.
Yeah, you cannot have employees telling stories about violently assaulting people on the manufacturing floor. That objectively creates a hostile environment.
Absolutely. The judge looked at the eggshells comment, the red-faced anger, and the assault story, and concluded the company easily met their Step 2 burden for that specific comment. They had a massive, documented, legitimate reason to score his coworker interaction poorly.
If the evaluation had stopped there, Montana Silversmiths would have won summary judgment and killed the entire lawsuit.
But the evaluation contained a second sentence.
The fatal error. Deacon wrote that Eaton sidesteps proper reporting of concerns outside management hierarchy. The court turns to the company's legal team and asks, articulate your legitimate, non-discriminatory reason for punishing an employee for sidestepping his boss.
And the company's defense was deeply rooted in traditional corporate culture. They argued that Eaton repeatedly bypassed his direct supervisor, going straight to HR and vice presidents to complain.
Right.
They framed this as a chronic failure to observe the chain of command and a refusal to resolve conflicts at the lowest possible level.
It's the classic management defense.
Mm-hmm.
Don't bother the executives with floor drama. But this is where the entire multi-year legal facade collapsed.
Absolutely collapses.
The district court judge looks past the depositions, past the matrix, past the medical leave, and pulls out Montana Silversmiths' own employee manual, the physical rule book distributed to every worker.
Yep.
The judge turns to page 8, the section specifically dealing with reporting concerns and harassment.
The language in a corporate handbook is rarely accidental. It is usually drafted by expensive employment lawyers to ensure federal compliance. The manual explicitly directed employees to discuss their concerns with their immediate supervisor, human resources, or any member of management.
Or R. It is a disjunctive list. The policy offers 3 separate, equally valid doors to walk through. You can go to your boss, or you can go to HR, or you can go to VP.
Exactly.
And when we look at Eaton's timeline, he went to HR in July 2015. He went to a VP later that year. He went to a manager in January 2017. He went to another VP in April 2017. Eaton was following the corporate manual to the exact letter.
The McDonnell-Douglas framework snaps shut like a bear trap. The judge wrote a devastating conclusion in the 2025 order. The court stated that the comment punishing Eaton for sidestepping proper reporting directly contravened the company's own employee manual.
You cannot look a federal judge in the eye and claim you have a legitimate, non-discriminatory reason for firing someone for violating a policy when the employee is doing exactly what the policy tells them to do.
Especially when the policy is designed specifically to allow victims to bypass the very supervisor who is harassing them.
It is legally indefensible. The judge concluded that Montana's Silversmiths completely failed to proffer a legitimate reason for that specific comment. Step 2 fails.
Because the company cannot provide a valid excuse, Eaton doesn't even need to proceed to step 3 to prove pretext. The retaliation claim regarding that single sentence survives summary judgment.
After 8 grueling years of litigation, the judge ruled that this piece of the lawsuit is going to trial. A jury will hear it.
It is a staggering irony. This company built an absolute fortress of legal defenses. They successfully shielded a massive 30-person layoff using complex economic data and cross-training algorithms.
They defeated an FMLA violation using nuanced Supreme Court definitions of prejudice. They swatted away age and disability claims.
But the entire fortress was breached by a single petty sentence written by an angry supervisor, approved by a vice president who didn't understand the rules written on page 8 of his own company's handbook.
It illustrates the true vulnerability of corporate employers. The macroeconomic defenses hold up, but Title VII recognizes that the individuals most likely to retaliate are the middle managers who feel personally threatened by a whistleblower.
And in their frustration, they almost always leave fingerprints. Deacon's fingerprint was his written annoyance that Eaton was talking to HR. He codified his retaliatory motive onto a permanent corporate record.
He handed the plaintiff the smoking gun, and the vice president co-signed it. But it took the courts years of scraping through the mud to isolate that single artifact from the noise of the massive corporate layoff and the screaming matches.
So what is the ultimate takeaway for the listener navigating their own career?
Even if your employer can legally terminate you during a massive algorithm-driven restructuring, the paper trail they build on you before the layoff is everything. We have to consider the chilling effect.
Right.
If a company can quietly punish you for raising a valid harassment complaint by dropping your annual review score, labeling you as not a team player, or sidestepping management, how many employees simply look at that dynamic and choose silence?
Sadly, a lot of them.
How many people realize that reporting a racist boss will artificially lower their metric, making them the most mathematically vulnerable person in the room when the next round of layoffs hits? Title VII exists precisely to break that cycle. True retaliation rarely looks like a dramatic firing. It looks like a vaguely worded sentence on a review that subtly alters the trajectory of your entire career.
And for anyone in management, the lesson is unsparing. If your leadership team doesn't know the exact reporting mechanisms outlined in your own handbook, or if they allow supervisors to penalize employees for using the safety valves you installed, all the sophisticated cross-training matrices in the world will not protect you from a federal jury.
We want to thank you for joining us today. Take a moment this week to actually look at your own company's reporting hierarchy. Do you know what the manual says? Because as the courts showed in this case, ignorance of the fine print can fund 8 years of litigation.
It really can.
When you first look at a termination, the ground appears solid. The company points to a spreadsheet, points to a massive loss in revenue, and tells everyone to move along. But if you have the patience to scrape away the sediment, to look past the medical leave disputes and the dramatic meetings, you might just find that one handwritten sentence that exposes exactly how power protects itself. The dirt always holds the truth. You just have to know where to dig.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own end at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to Carey at capclaw.com. That's capclaw.com.